Welcome back, everyone. We will now present From Revolution to Constitution, Part 2 of our lecture of the coming of the American Constitution. We saw how in the first part of this lecture that a profound disagreement among those who had supported the American Revolution, a profound disagreement over the meaning and character of democracy, would fuel a growing number of conflicts in the nation, the United States, as it had been proclaimed during the Revolution, and under the Articles of Confederation, chartered as the United States of America. But no sooner had the Revolutionary War ended than this disagreement would inspire not only a series of conflicts, but also, as I say, profound disagreements over the very nature of democracy itself. And as we saw, a small but influential group of men who openly feared for the domestic tranquility of the country, that is the basic public order of the country, had by 1787 come to convene in Philadelphia, Pennsylvania, ostensibly for the purpose of merely revisiting and revising the Articles of Confederation. What these men ended up doing, of course, was something very, very different. 55 delegates from each of the 13 states, though initially Rhode Island remained aloof from the proceedings, 55 delegates met behind locked doors during the sweltering summer months of 1787 and entangled and engaged themselves in a rethinking of liberty and order, the fundamental concepts now that would form their business, as they rather quickly decided not to merely revise the Articles of Confederation, but to create an entire new document, a document that, of course, we know as the U.S. Constitution. And most famously, in the preamble to that document, they would declare their fundamental commitment to popular sovereignty with the words, "We the people." We the people, not we the Congress, we the convention, we the elites, we the men, but rather we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America. And so they declared this to be a new document, a Constitution for the United States of America, whose chief purpose they had listed in the preamble, included in the list, a more perfect union, as if the union as it then existed under the Articles was not perfect enough. Justice, domestic tranquility, again, a due regard for what they considered to be the order, the public order, the law and order of the country, as it would have to temper what in their minds had been the excesses of democracy. So a famous preamble, which many school kids in America over the years, of course, have learned to memorize, although it's worth saying, often confused are these words with those of the Declaration of Independence and vice versa. But it really prompts a question, I think, that too often is overlooked. Who exactly were the people? Well, if we look at the breakdown of the constitutional delegates, those whom we'd come to call the Founding Fathers in later years, we would see an assemblage of men who were surprisingly young of age, an average age, in fact, of only 42. Some of the youngest among them being only in their early 30s, including James Madison, sometimes called the father of the Constitution. A dozen of them were lawyers. Another dozen were political office holders. About a dozen of them were Revolutionary War veterans. A third of them owned slaves. And several were propertied men, that is, investors in land and property, including the lands beyond the Appalachian Mountain Range, what then would have been known as the Western Territories. This is important, as we'll see, because among other things, one of the chief concerns of the framers of the Constitution was the protection of property rights and the claims of property owners. In sum, we could say of the framers and Constitutional Convention delegates that they were, quote, well-bred, well-fed, well-read, and well-wed. In other words, elites. Who was not included in the Constitutional Convention, that is, in the assemblage of those who declared we the people? Well, certainly not the poor or the uneducated, not the backcountry people, not non-voters, not women, not a single woman at the Constitutional Convention, not Native people, that is Indians, and none of the 500,000 or so enslaved men, women, and children of the country. None of them were included in the Constitutional Convention. So you could say those who did participate represented a rather small in number but politically and financially influential elite. And it was they who presumed now to speak on behalf of the people. The delegates decided almost immediately that their meetings that summer should proceed in private, that is, behind locked doors in the room you see here in the picture, the assembly room in what we now call Independence Hall, where the Declaration of Independence had been signed just over a decade earlier, and where the Constitutional Convention delegates would again meet in 1787, the summer of 87. They also agreed that not only would they meet behind locked doors, but that none of the notes that any of them took would be made available to the public, that is, to the newspapers or the general public, until the last of them had died, and that would be the youngest delegate, James Madison, who took the most extensive notes of the convention. He would not die until 1836, and thus his notes not made public for the first time until 1840. So over 50 years after the convention would the first of the delegates' transcripted notes be made public. And it raises a question again, why was this assembly that was carried out in the name of the people conduct its business essentially in secret? And that's something that historians have long pondered, of course, and debated. But it seems that perhaps the essential reason was so that their business might not be subverted or unnecessarily delayed by public squabble or by intervention of those not a part of the assembly. In other words, they wished to create the document in whole before introducing it to the country at large, so that it might then achieve a vote as it stood, rather than be forever caught up in, as I say, public disagreement or debate. So a rather pronounced non-democratic approach, you might say, to the document that would come to embody the essential nature of our democracy. The cure of the republic, as the framers saw it, removed governing from the confusion of popular democracy, as experiments in democracy would become Americanized. In other words, in the language of the framers, the excesses of popular democracy would become now more thoroughly Americanized under a constitutional form of government that would ensure domestic tranquility and public order. And this would be, of course, one of the most controversial aspects of the new Constitution, because there would be those critics, of course, who claimed that what the framers were really doing was taking the heart out of American democracy. Now, James Madison, the young delegate from Virginia, whose notes would form the essential transcript of the proceedings many years later, would publish at the time of the ratification of the Constitution a series of articles that would come to be known as the Federalist Papers, along with Alexander Hamilton and John Jay. And Madison's Federalist 51, as it is known, addresses this very issue about the need to provide certain safeguards against the excesses of democracy. In Madison's words, if men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. A dependence on the people is no doubt the primary control on the government, but experience has taught mankind the necessity of external precautions. And so among the irony of Madison's statement here is that to preserve democracy, the excesses of the people would have to be controlled by a government sufficiently powerful to take up that task. And yet, the great threat to liberty in history being the excess of government power, the government that they then created would also have to rein in its own excesses. And ultimately, it would be the people whose own proclivity toward excess Madison and the others wished to curtail. It would nevertheless be the people now who would form the chief arbiter of the government. Get it? Yeah, sure. A kind of entanglement that only the framers at the time felt they could sufficiently reconcile. The chief challenge in the minds of the convention delegates was to create a sufficiently powerful government to curb the excesses of democracy and provide for general order. But that, of course, led to other questions. And the chief question was, where could you trust that power in government to reside? Now, Madison and the other framers debated this, of course, during the summer of '87, and as we know now, came up with at least two major options in answer to the question. The first, the so-called Virginia Plan, put forward by delegates from Virginia, called for a two-house or bicameral legislature in which both of the houses would be based on proportional representation. That is, representation based on the population of the individual states, sometimes called the big state plan, because at the time Virginia had a relatively large population. A counter plan known as the New Jersey or small state plan proposed a single house or unicameral legislature in which every state had an equal number of votes regardless of the state's population. The fear here, of course, among the small state delegates was that the large states like Virginia, would simply overwhelm the Congress with their greater proportion of delegates and thus deny the smaller states, that is, states smaller in population, an equal voice in the government. In the end, the so-called Great Compromise settled on by the delegates saw a two-house Congress based on the elements of both these plans. A House of Representatives, in other words, based on population, and a Senate based on an equal number of votes, 2 per state. Well, that seemed to resolve the business of population. But how to safeguard against other pernicious influences, none more so than what the framers called factions and what we would call these days special interests. In other words, how to create a government that would sufficiently protect the interests of the public against the interests of the specially interested, that is, against the factions that might seek to subvert control of the government. And it was here, in many respects, that the genius of the framers played out, because instead of entrusting all the power to this branch or that branch, or to the National Congress, or to the individual states, a system of so-called federal government, inhering divided powers, spread and shared among not only the various branches of the government, but between the National Congress and the states, was created, in which diversity and sheer size would offer the greatest protection. And here's what that meant. Again, according to James Madison, a manufacturing interest, a mercantile interest, a moneyed interest, with many lesser interests grown up of necessity in civilized nations, and divide them into different classes activated by different sentiments and views. That was Madison's argument, famous argument in the Federalist number 10, in which he was saying essentially that it was the very diversity of America and America's interests that would actually protect it from the rise of a single or special interest. That is, our diversity would protect us against the rise of a kind of monopoly interest, you might say. Whilst all authority in it will be derived from and dependent on the society itself will be broken into so many parts, interest, and classes of citizens that the rights of individuals or of the minority will be in little danger from interested combinations of the majority. In a free government, the security for civil rights must be the same as that for religious rights. It consists in the one case in the multiplicity of interests, and in the other in the multiplicity of sects. So again, this time in Federalist 51, Madison arguing that the very size, the enormous size and diversity of the country would serve as a check against the consolidation of power by any one interest. That is, our multiplicity of interests, as he said, would safeguard us from the rise of a single monopolied interest. And these arguments, which came to be called the Federalist Papers, serve even to our own time as a kind of blueprint of political science, you might say, behind the essential system of government that the framers created, our constitutional or federal system of government. And the reason why Madison spent so much time on this vexing question of special interests is because there were those who were particularly concerned that this constitution would form a consolidated or monopolied interest separated from the states, situated in a single city or capital, ruled by a junta of men whose own connection to the various and separate states and localities could not always be guaranteed. But in creating the federal system, it was Madison's chief aim, along with his fellow delegates, that power would not be consolidated in such a fashion, and that the enormous variety of interests represented by the Congress would mean that no single interest could ever predominate. And I mention that again because sometimes we complain about special interests. Well, Madison knew that special interests were inherent in any society. There was no sense in trying to legislate them out of existence. The point was to keep them in a relative balance, one against the others, so that no one of them could ever predominate. And it was the particular nature of the United States and its diversity that Madison felt would help in this cause. The Constitution that they created was a blueprint for shared power. In other words, a shared power that could temper democracy. As we learn in our civics classes, a system of checks and balances spread among three main branches of the central government: the Congress, itself made up of two houses; an executive branch or presidential branch made up of a single elected chief executive. And though it was not as specifically defined in the Constitution in terms of its sphere of powers, a Supreme Court or judicial branch represented by a Supreme Court and a host of associate courts would form the third branch in this system of federal government. Now, this represent, of course, the national government per se, but it was also understood in this Constitution that the national government would share powers with the several states of the Union, those states in turn being made up of several municipal and local governments as well. So a system of checks and balances where power, the power to government, the power to enforce laws, the power to rule, in effect, would be spread among various branches so as not to consolidate in any one of them, creating what the historian Richard Hofstadter called a harmonious system of mutual frustration. And I love here Hofstadter's phrase because it's often, again, a particular frustration of the American people that our government, particularly our national or federal government, seems so slow to move, so bound up in special interests, so caught up in red tape. But in a basic way, as Hofstadter implies here, the framers meant that it deliberately be so. That it be difficult, for example, for a single special interest or a single branch of government to fast track through great legislative changes, or for a single party or a single governing interest to consolidate and thus usurp the power. Only by spreading power out, by dividing it, by checking interests one against the other, could that basic safeguard of the corrupting influence of power be better ensured. Fierce debates on the structure of this new government ensued almost as soon as the document was publicly proclaimed. And special state conventions then called to decide the fate of this document, this Constitution, throughout a ratification process. In other words, for the document to become the formal law of the land, the states would have to ratify or approve it according to a process laid out. Now, almost right away, the document had some very well-known critics, and among the most influential of these critics that is, critics of the proposed Constitution, was Virginia's Patrick Henry, the great revolutionary Patrick Henry, who feared that the power of a central authority, as such created by the Constitution, would be a great threat to the liberties of individuals and of the several states. Now, Henry would finally accept the Constitution, but only after it was arranged that a so-called Bill of Rights would be created to accompany the document, a Bill of Rights that would specifically express certain safeguards for the rights, particularly of individuals. During his speech, his famous speech in the Virginia Ratification Convention, Henry had put voice to his fears. This proposal of altering our federal government, he said, is of a most alarming nature. Make the best of this new government. Say it is composed by anything but inspiration. You ought to be extremely cautious, watchful, jealous of your liberty. For instead of securing your rights, you may lose them forever. If a wrong step be now made, the republic may be lost forever. If this new government will not come up to the expectation of the people, and they shall be disappointed, their liberty will be lost, and tyranny must and will arise. I repeat it again, and I beg gentlemen to consider that a wrong step made now will plunge us into misery, and our republic will be lost. So, striking is the apprehension here of Patrick Henry for the dangers that the new Constitution portended. Now, as I've already suggested, Henry will be brought around ultimately to supporting the ratification of the document, but only after the promise of a Bill of Rights that would be amended to the Constitution and would expressly protect the rights of individuals against the power of government. Henry was not alone in fearing the centralizing power of the government which this Constitution proposed. A fellow Virginian by the name of George Mason, a veteran of the Revolution, said the very idea of converting what was formerly a confederation to a consolidated government is totally subversive of every principle which has hitherto governed us. This power is calculated to annihilate totally state governments. Now, Mason and Henry and some of their fellow Virginians who initially opposed the Constitution have sometimes been painted as anti-federalists, as men of little faith who somehow stood in the way of the great document. But remember, at the time, in 1787, as these ratification conventions were called and the document we know as the Constitution was examined, there was only history really to guide them in their judgments of it. And what history suggested is that when central governments were created, powerful central governments, more powerful than the national government under the Articles of Confederation had intended to be, that when these powerful central governments were created, that typically the liberties of individuals were jeopardized as kings and emperors and armies consolidated power over the people. And so, rather than seeing them as men of little faith, I think we should see Patrick Henry and George Mason and others who opposed the Constitution as men who simply understood that the lessons of history taught that democracies were typically destroyed by consolidated governments. And notice by July of 1788, the Virginia Constitutional Convention had concluded its business. And as this handbill, which was spread throughout the states, suggested, a narrow victory by those who supported the ratification of the Constitution. This is really critical, as we'll see, because had Virginia not gone along with the ratification of the Constitution, it's quite unlikely the document could not have been functionally adopted. But the questions which Henry raised and which Mason raised, I think deserve maybe a respectful hearing. And so we ask, in the end, were they right? Was the government that was created a consolidated government? Well, if you look at different articles and sections of the Constitution, you can see why they were concerned. Consider this one. This is from Article 1, Section 8, which is the defining article of Congress. And according to Article 1, Section 8, the Congress shall have power to lay and collect taxes. Remember, it had been taxes that had sparked the American Revolution in the first place, and particularly the claim that the central government of England had not exercised proper due process in levying taxes against the colonists. So right from the beginning, the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. Provide for the common defense, one would assume securing borders and raising a military. But all duties, imposts, and excises shall be uniform throughout the United States. And so now it would be this Congress, this central government, that would essentially define the uniform character of all taxation, all duties, all imposts, all excises for the country. That's not to say that states could, in addition, tax themselves, or municipalities could not, in addition to tax themselves, but that the proper sphere of national taxation would belong, according to the Constitution, to this new government. But they weren't done. The framers also expressed that this national government would have the power to, quote, borrow money on the credit of the United States, to regulate commerce with foreign nations and among the several states and with the Indian tribes, to establish a uniform rule of naturalization, that is a process whereby individuals could become citizens of the country, to coin money, regulate the value thereof, to provide for the punishment of counterfeiting, to establish post roads and post offices, to promote the progress of science and useful arts, as we would know it in the instituting of and delegating of patents, to constitute tribunals, that is other courts, to define and punish piracies, to declare war, to raise and support armies. And if that weren't enough, the so-called elastic clause allowed Congress furthermore to, quote, make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution in the government of the United States. So in effect, what the framers were saying is that in case they had neglected to include something, that Congress and this national government would nevertheless still have the authority to make additional laws that would preserve the central authority, integrity of the national government. So yeah, when you look back, you kind of see why men like Mason, George Mason, and Patrick Henry and others were concerned at the amount of power being reserved now in this new constitutional system to the national government. And how did the vote play out? Well, as we can see here, it was close. If you look at the map, the two colors, the purple and sort of canary color there, represents the division within the individual states between those who supported the Constitution, those areas that supported the Constitution, that is those in purple, the so-called Federalists, and those who opposed it, those areas in that sort of canary or yellowish color, that we sometimes call anti-federalist. And if we look at certain key states, we see just how close the vote was to ratify. In Massachusetts, for example, the state convention voted 187 to 168 in favor of the Constitution. So about 10 votes different. That is, if 10 delegates had voted different, then Massachusetts doesn't pass. By June of 1788, as we saw, Virginia had indeed approved the Constitution, but again by a very close margin. 10 votes separating the pro versus anti-constitutional voting bloc. A 10-vote difference, meaning that had 6 delegates voted differently, Virginia would not have ratified. The vote was even closer in New York. The great state of New York barely approved the Constitution, 30 to 27. A couple of votes going the other way would have been enough to keep New York from ratifying. And it's safe to say that if these states, Massachusetts, Virginia, and New York, the richest, most powerful, most populous states at the time, had they not voted in favor of the Constitution, there's no practical way the Constitution could have taken effect. This is sometimes forgotten, as we have subsequently sort of mythologized the Constitution, the miracle in Philadelphia, as one writer famously called it. Well, that miracle was seen as a threat by many, and in the end, the debates were vigorous and intense, and the votes were very close. But as close as they were, of course, the Constitution was therefore ratified, and thus has been the central law of our land ever since. It's worth pointing out that it was one division in particular, a division, though not even mentioned by name in the document, that was guaranteed to remain a law in this new republic under the Constitution. And that division was, of course, the division over slavery. And it was several compromises during the convention that ensured slavery's survival. Remember, I said a third of the framers of the Constitution were themselves slave owners, including George Washington, including James Madison. Though you'll look in vain in the original Constitution, in the document they wrote, to find the word slavery identified. Instead, you'll see sectional language in the Constitution, such as the famous 3/5 clause, where according to a state's population, including 3/5 of all other persons, that is, all other persons besides free persons, meaning slaves, would be counted for representation. The slave-owning states, of course, wanted this inserted. The non-slave-owning states, fearing the majority of slave-owning states, did not want enslaved people counted. And we know that the debates were fairly intense. But in the end, the compromise was to say that 3 out of every 5 enslaved persons would be counted for purposes of determining representation in Congress. Another example, Article 1, Section 9, the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by Congress prior to the year 1808. This was the compromise that said that the Atlantic slave trade would lawfully continue in the country for at least 20 years, and that not until the year 1808 would Congress have the option of abolishing the Atlantic slave trade if it saw fit. So what do we make of this? We say that the framers of the Constitution felt that the free importation of enslaved persons, the buying of slaves from the Atlantic market, should be not interfered with for at least 20 years. As it so happens that in 1808 the Congress would abolish the Atlantic slave trade, though not abolish slavery itself. and the buying and selling of slaves internal to the country, the so-called domestic slave trade, would continue to broker men and women and children as enslaved persons all the way down to the end of the Civil War in 1865. Now, this compromise over slavery was created in order to preserve the Union and to forestall division between slave and non-slave holding states. But as we know, that compromise would prove to be insufficient in the end to keep the country from dividing exactly along those lines. And yet, in a land where slavery had long underwritten freedom, it was nevertheless agreed, as I mentioned earlier, that a Bill of Rights would be added to the Constitution specifying individual liberties, but individual liberties only for free citizens. And in the very first amendment to the Constitution, the very first of these so-called Bills of Right, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. The First Amendment to the Constitution, embodying the basic civil rights as we know them, originally expressly guaranteed only for free citizens. And thus was born, you might say, with the ratification of the Constitution in 1788, a great experiment in popular sovereignty. And as the Latin motto adopted earlier by the Articles of Confederation government held, e pluribus unum, a Latin phrase, out of many comes one. That was the essential hope of the framers, that this new constitutional republic, born of the promise of popular sovereignty and of we the people, would unite a diverse nation of many interests, of many states, of localities, of national interests, knit it all together in a single functioning republic. Well, how'd that work out? At this point, we have much story still to tell, and so I will leave it to our future lectures to begin assessing the fruits of this constitutional republic, beginning right away in the 1790s, in the period we know as the early republic, and our lectures to follow.